Hello, ladies and gentlemen. Today we're here to present you our newest product, Vico Smart Glasses.
As a user of the Vico Smart Glasses, you can use a swivel arm on the product to switch between a large mirror with an augmented reality display and a small screen that resembles a dashboard. Its high-resolution display perfectly matches with our own helpful software support. Vico glasses use remote wiring technology, similar to the VCRs of the early 1980s, which have a more mundane appearance, but you can tell we are taking the low-key and subtle route. What's more, its creative, interesting, and informative application coming along with reality support technology regarding object cognition makes up for the shortcomings in appearance. The glasses use a dual projection design, and the augmented reality image can cover the user's entire field of view, while real environment in front of them will not be blocked. Vico glasses are designed for all ordinary consumers, which integrates a dual-core processor, graphics processor, GPS, high-definition camera, wireless connectivity, and more. It is a boon for careless workers who live or work in an especially unsafe, risky, and chaotic area. The more you know, the more you can protect yourself and others from harm. With it, you can take pictures at any time, track certain targets, and plan the best route to destination without taking the risk of looking down at a phone.
Moving on to trademarks. So for starters, a trademark is a logo, symbol, or mark that is both distinctive and non-functional. A common law form of property by the Lanham Act and is good for 10 years as well as can be renewed. Our trademark name Vico is classified as arbitrary and fanciful, which is most favored because they're both inherently distinctive and made up. Additionally, by the Lanham Act, we file all of our trademarks at the Patent and Trademark Office. For our trademarks, Vico has first its name, Vico, which is classified as a Code 4 trademark because it is trademarking the word itself, regardless of font size, style, or any other things. Second, we have Vico Glasses, which is also a Code 4 trademark. And lastly, we have our logo and symbol, which is a Code 3 trademark because it is a combination of our design and our name. All three trademarks are specific to our company and are filed at the Patent and Trademark Office.
We will also be using trade dress. There are two important elements of trade dress for our product: distinctiveness and functionality. Our product is distinct in its non-functional design of the two cat ear-like spikes on each end of the frame. We will register our trade dress officially at the USPTO with intent to use and under Class 9 of goods and services, which includes glasses.
When it comes to copyright, our product is protected under U.S. Code 17, Section 106, which protects the rights to reproduce and sell all of our marketing advertisements, materials, and our app icon of the patent. And furthermore, our product is protected under several different patents. The first two patents are utility patents on our app's coding design, as well as the precise object recognition it has. And lastly, our third patent is a design patent on our unique overall product.
We do not have the trade secret for our products because we expect that our product will not be commercially viable through technology innovations. So we think it is just enough to use patents to protect our products.
Now on to Vico contracts, beginning with employer agreements. The employees agree to first a non-disclosure agreement, meaning they must not disclose any confidential information about Vico during their time of employment or for a period of time after. Second, we have the non-compete clause, meaning that employees must not enter into competition with us as an employer during the time of their employment or for a period of time after. Next, we have the work to hire agreement, which is simply just them working for us and us paying them in money for compensation. Lastly, we have the non-solicitation agreement, meaning that employees must not solicitate any of Vico's clients or information to competitors for their own competitor benefit. For our buyers, they first agree to our terms and services, terms of use and conditions, limited liability clause. Next, binding mandatory arbitration, agreeing to resolve disputes of the contract with an arbitrator and not in court. Lastly, we have our general contracts. First, the protection of our IP ownership. Next, we have our invention assignment agreement, meaning that employees bring up an idea or create an invention during their time of employment us as an employer have rights over that idea or invention. So you have the disclaimer of warranties clause, meaning informing our buyers that we are not bound to any warranty promises of our product.